Good morning. We are so happy to have you here, and I'm sure you've got a lot to cover. So we want to give you as much time as possible. I think we can go until about 9:15 if that works for you. 9:40. We have a few properties to pitch, but we'd like to give you as much floor time as possible.
Okay. Good morning, everybody. I recognize some people who have heard me talk about some of these subjects previously, so hang in there. But I don't know about you guys, but the last 40 days, 45 days have been spent sorting through deposit disputes over COVID and over people, buyers especially, obviously, saying that they are not able to perform because of a decline in their stock portfolios or some other issues like that. Most of those have resolved. I've got about 3 or so that are still pending. They are large enough deposits that people can, spend some money fighting about them. But I've got a couple more that have come in this week. But I guess what I'm seeing is that now that we've been in this SIP situation for the period of time that we have, I think that we are now shifting more towards, all right, how can we conduct business going forward? I did an article, which you can see on my firm's website, that discussed what I had experienced in the last 30 to 40 days. I guess the key to this is, if in fact somebody thinks that COVID justifies or excuses non-performance, before you generate anything, please stop, at least talk to your manager. I don't like to promote saying talk to lawyers, but what you say, how you phrase it, both in emails and in any COVID, addendum that you provide, can have an impact. Just as anytime we fill out a cancellation, what we specify or designate in that cancellation can and might be used to try to lock somebody into a particular position. So, for example, if a car cancellation form is being used and it is a unilateral cancellation, to fill out that form and say it's by mutual agreement, obviously is going to get rejected by a savvy or focused seller's agent and seller. If you check off the box other and don't fill something in, then if you've said something in an email, you may be held to what's in the email or the text message. One of the other things to just remember is that if we're using the CAR contract and we have liquidated damages initialed, the deposit is not the sole and exclusive remedy that a seller has. A seller can, if they choose to do so, sue for specific performance, and that is a remedy which is not certainly guaranteed, and there are a lot of issues that come with it, one of which is unless you can get a stipulation between the parties, the seller would have to hold the property off the market and obviously be able to sell or convey it to the buyer in the event they were successful in their specific performance action. However, a lot of buyers don't realize that they may have that risk. What is the primary risk? The risk is that if specific performance is granted and the property is not then purchased by the buyer, which is what happens, the buyer is given a period of time in which to purchase it. They can't be compelled or forced to purchase it. But then what happens is the property is sold either by auction or on the market. And if it sells at that point in time at a loss greater than the deposit, there is the ability to seek damages incidental to a specific performance decree for that difference. So if the market is going to drop and the drop will be greater than the contract price that we entered into, then, and that is greater than the deposit, that is the potential risk. What advantage this has given me is I have been able to convince buyers that it might be better to part with the deposit at this moment in time rather than expose themselves to the risk of a specific performance action. I have 3 sellers right now who don't need to sell, so they can, in 2 instances, the property is still occupied by a tenant. In another, it's occupied by the seller. So they don't have any pressure, you know, as some of my other sellers did, who said, well, that's a great theory, Dave. Glad you told me about it, but can't afford to hold the property for, you know, the period of time that it'll take to complete a specific performance action. But it has been useful as a, dare I say, threat or attempt to focus and get the buyers to realize that their deposit may be at risk. Now, if you are going to try to preserve that right, please remember that the car cancellation form will need to be modified in some respects. And what I'm talking about specifically is the last 3 pre-printed lines at the bottom of the cancellation form, because there is some release language in there, and some of that language addresses that parties are giving up the obligation or right to buy or sell. And if you're pursuing specific performance, you would want to make sure that you are preserving the right to compel performance. The other thing that should be cleaned up in that is if we still have a dispute over the deposit and we've got mediation, arbitration, and an attorney's fees clause, which we do in the car contract, then we would want to preserve or spell out that those remedies and rights still remain irrespective of the release language at the bottom. The other thing is paragraph 2C of that form, which is where the deposit is held in escrow. It assumes that there's been a mutual cancellation. So I have been deleting the word mutual. At least there's 2 references to that word in that sentence. I have been deleting the first reference if in fact it is not a mutual cancellation. The other thing that you need to be aware of course, is if a buyer is unilaterally canceling, what impact does that have on notices to perform and or demands to close escrow? It all depends on what the language says, whether it is in fact an anticipatory breach or repudiation of the agreement, which would therefore excuse further performance or not. Any response that I've been making tries to clarify that so that we can not have to go forward with those other actions. Let's talk briefly about COVID-19 just in the abstract. Everybody appreciates that the contract does not contain any force majeure language, which is why there are now all these addendums, you know, that have been created to try to insert or inject that into the transaction. Does everybody agree, I hope, that any addendum like that or an amendment is going to need to be accepted by both parties in order to be enforceable or binding? In the event that it is not, so it's presented, and most of the sellers that I've been representing have been rejecting it, you know, based upon the terms and conditions of the agreement that they have already signed with the buyer. And their position has been, for example, well, you wrote a non-contingent offer. The fact that you wanted to go out and get financing and have now had a problem or a dilemma doing so is not my problem. The other situation that has certainly arose in the last 40 days is, well, my stock value went down. I've lost my job. I may lose my job. My gift money, which was coming from my parents, has evaporated because my parents' stock portfolio or money went down. We've all heard all of these, you know, stories. And most of the deals that I have looked at involved non-contingent offers, and they were aware of COVID at the time that they wrote them and simply didn't include any contingencies to cover these sorts of events. So in those circumstances, unless you can show a direct causal connection between the COVID impact and the ability to perform, I don't have a lot of sympathy for these buyers. Obviously, every one of these cases, you have to look at all the facts, all the statements, all the issues, but in general, there's got to be that direct causal connection. We experienced that at the beginning of this process back in, what was it, March 17th, 18th, 19th, 20th, where some banks, some title companies literally were not operating or functioning, but that got addressed. So we're really now left with most of the circumstances are the buyers have lost confidence because of decline in value, decline in stock portfolio, can't get the loan they anticipated getting, even though that wasn't part of the terms of the deal. I think the more interesting one might be the following. There was a loan contingency. They have in good faith applied for that loan. They were approved for that loan. They removed their contingency and then lost their job or something. There was a requalification by the bank. Perhaps their reserves are not what they were to begin with. Something has changed, and the bank is now saying, well, we're not going to give you the money. Now, how many of us think that that is too bad and the buyer has to accept the consequences of the fact that they removed their financing contingency, even though they may have lost their job, lost their income, the bank now isn't going to fund? That's one argument, one side of this little problem. The other is, if we look at paragraph 14F, I believe, of our contract, which is the effect of contingency removal, one of the provisions in that paragraph, if you look at the last 4 or 5 words, are you take the risks that your financing doesn't come through. So the counter side to this, the counter argument will be, why is this risk any different than the one that all of us take whenever we remove a contingency and there is some period of time between close of the removal and close of escrow? It is a risk that we've been taking for years. Many people have not been able to get the loan that they thought. How have we dealt with that in those timeframes? So those are the two competing arguments. Of course, I would love to tell you that I have the absolute definitive answer. And if I did, I would not be on this conference call with you. I would be on my yacht sailing around the world and enjoying life like we all would, I'm afraid. So unfortunately, we're again left with arguments. And in the real world of an arbitration, a courtroom, unfortunately, predicting the outcome of that is harder to do. I mean, is somebody going to feel sympathetic for the buyer that has acted, in good faith, but simply lost their job? What is the seller's position? Is the seller somebody who has other assets, who has the ability to withstand this problem or loss? And those are factors that you can't underestimate. But that's pretty much what I have been seeing for the last 40 days. Now, going forward, I don't understand why any of you think that it is so difficult to actually sell a property right now. I mean, for God's sakes, all you have to do is have a vacant property and disinfect it, to the millionth degree. And if it's priced, less than 1/8, I'm seeing that there's a lot of multiple offers on those situations. All kidding aside, the first and foremost issue that we've got to consider at this point in time is, can we actually conduct the transaction that we want under the local SIP order that is in place? And that is something that requires that we evaluate each order where the property is located, although there is an awful lot of an attempt on the part of our industry and others to try to say that these are all more or less the same. The language is different from county to county to some degree. They were drafted by health officials and maybe county council. They may have a different sense or understanding of the words, that they chose. I think we should apply some common sense interpretation of the words that are in there. So if the property needs to be vacant, if the property can't be occupied, if the property requires that no one be residing in it, what do these basically mean? Well, I'm afraid they mean probably that they are vacant and nobody is or has been residing in it. So here are some things to consider. The Santa Clara order, at least the current one, another thing to remember is we're probably going to get a new one of these orders, at the end of this week, is what I've been hearing. So are they going to give us any further guidance or clarity on what we can or cannot do with occupied properties? That's obviously the hope. We'll have to wait and see. But one of the issues in the current order is that an essential activity is defined, quote, to move residences, but only if it is not possible to defer an already planned move. If the move is necessitated by safety, sanitation, or habitability reasons, or if the move is necessary to preserve access to shelter. So I actually had one of these issues a couple weeks ago where the client really didn't need to move. It was a discretionary, voluntary move and had time to do so. And the question was that an essential activity such that he could, in fact, move under the current SIP order? So we talked about that. Everybody, I assume, is aware that the consequences of it, it's a misdemeanor if we're found to have been in violation of it. In other words, fine, imprisonment, believe it or not. Anecdotally, I have actually heard that there are certain counties around the Bay Area where the police and authorities are now actually stopping cars to find out if those people are actually conducting some activity that is permitted or not. And so, we just need to obviously follow the law, and it may be frustrating, but we need to be sensitive that there may be some repercussions. If in fact, yes.
Dave, I hate to interrupt you. I just want to ask a couple things because they're right along this same vein. One is somebody just wanted to clarify, like for Santa Clara County, when it says a property is vacant, my understanding, you can clarify this, is that the seller isn't living there, period. Not just stepping out or the tenant. The property is actually truly vacant, correct?
All right. So here is the answer to this question.
Okay.
Do I actually know how that particular language is going to be interpreted or not? The answer really is no, because I've not had any discussions with county council. I haven't had any discussions with a health officer. However, Kelly, it is my common sense interpretation that vacant means what you've just described, so that it doesn't mean I just stepped out for a powder, and
right.
wanted to get I stepped into the suntan booth, and it suddenly magically is, open. Now, is there another question on this line, or I can continue?
Actually, it was more of just a comment, I think, along the lines that there are agents out there that are allowing occupied properties to be shown and just step out.
Well, you just anticipated my next thought.
Perfect.
Okay. Yeah, I have heard that. Am I surprised? No.
No.
Why? Because, there are always going to be people that are looking for what I'll characterize as a workaround, right? I'll just look the other way and this will happen and it will not be a problem. What are the consequences of that? Well, certainly the consequences are that you have violated potentially, an ordinance. It's a misdemeanor. Conceivably, if you wanted to play devil's advocate, one could say you are aiding and abetting. Those are fancy words for you're basically assisting somebody to commit, an illegal act. What potentially could be the consequences of that? Well, depending upon a seller, let's say a seller says, well, I relied on you, my agent, you told me I could do this. I relied on you, and that was believed. Then maybe whatever liability existed could get passed through to, an agent or a brokerage. That's one of the potential risks. If it's an illegal transaction, what are the consequences of that? Arguably, again, we're talking arguably, might the listing be voided, or voidable as a result of that? Conceivably, yes. Whether a buyer who knowingly participated in that transaction waived that right or not is another, issue that I haven't encountered yet. I haven't heard anything about. I guess what I would like to say is this. If we take a step back and we look at what's going on, we have some of us who are concerned about health and safety, the general welfare, of the public and the community, and that concern overrides, any other concern. Then we have a group of us who say the economic consequences of that philosophy are going to bury us. And I mean, I'm not saying anything I think that's earth-shattering. This is what is trying to be balanced and figured out, nationally, statewide, locally. And the point of this is simply, we're always going to have people who are going to lean one way or the other, of those two philosophies. My concern for anybody is that there may be people who hold a different philosophy and who may then want to make an ethics claim, if in fact it is an ethics violation or not. I've seen some literature about that. They may be jealous because they're not doing any business. They may, just feel that it's not appropriate for anybody to do any business at this time for the reasons, that the public and the government has indicated. You just need to be careful about it. And I don't condone any violation of any of these orders. And that is the issue, is what are the restrictions or limitations on access provided by an SIP. And Santa Clara does talk about if the property is otherwise occupied, then access is not permitted. That's the potential interpretation of that. Whether we are going to reach a point where that gets changed may happen. I was at a caucus yesterday for my board, and I heard about a custom that is now in place in Seattle. Seattle is a couple of weeks, according to the individual who passed on this information, a couple of weeks ahead of us, in terms of confronting this. And what they apparently have agreed or accomplished was that property will be put on the market. There will be a date certain when offers will be received, and then there will be a schedule set up for access to the property. Everybody goes in on a day or 2 days, and somebody comes in and disinfects the place, completely after that is accomplished. whether we're going to get there and whether we get there in 2 weeks or 4 weeks, we need to be kind of focused on. My reaction to that was I thought that it was creative and resourceful, but I then said, well, what happens if we don't get any offers? And then how do we deal with it, going forward? The other thing to remember in this regard is that we have to get the seller's agreement on access. So access may in fact be prohibited by an SIP order, but if access is also going to be prohibited or eliminated by a seller, we've got to deal with that. Obviously, and by the way, everybody I assume is familiar with the most recent iterations of the CAR COVID addendum, the amendment to the listing, and the PED, and then NUC. So they address these things in there, but clearly a seller who doesn't want to allow access has to understand the impact that that may have on their ability to sell the property and the value and desirability of the property. Conversely, a buyer who is still willing to go forward with access that is limited needs to probably have some specific documentation provided to them, drafted by, I hate to say it, a qualified California real estate attorney, to address the risks that they are taking, in the event that they move forward with the purchase of a transaction without having had the ability to access it or inspect it, in any particular way. Many of you know my friend and colleague, Vicki Nadorf. She and her partner, Bill Jansen of Broker Risk Management, have got, material that they've created. I don't know, some of you may or not be clients of theirs, but the point is there's got to be, something drafted that clears up these risks. The other thing to remember is that the purchase contract provides the buyer with what? The right to look at the property, whether they've got inspection contingencies or not. What is the default clause? I think it's 17 days, to get in there, still under paragraph 14, I believe. And so the contract's going to have to be modified, in some way to say, you don't have these rights, so before you have somebody sign that contract, they probably need to have a consultation with a lawyer to make sure that they've got something drafted that covers, that scenario. Here are a few things I'd like you to think about when talking to sellers. Assuming the transaction does not violate, an SIP order, where is the seller going? Can they get there? In other words, do they have the ability to get where they want to go, or will that in and of itself trigger a violation of an SIP order? Do they need a contingency to address any of these issues? Second thing, what is the current health of the seller? Do they have any specific concerns about being exposed to COVID, given what they do for a living? And as a result, do we want to address their ability to get out of a deal in the event that the unfortunate circumstance comes down to that?
Dave, can I ask you a question real quick?
Sure.
Okay, so with regard to moving, one of the agents was, and I'm pretty sure I understand the answer to this, but I want to ask you, when it comes to moving, a renter buys a house, they close escrow, the property's vacant, they're able to move in. It's my understanding that SIP does allow movers to move them as an essential service. Is that correct?
Again,
or to your understanding, especially your
yeah. I mean,
okay.
I don't have the absolute answers, and nobody should be relying on my interpretation of these. Is that a reasonable common sense interpretation? Yes, but again, exactly what the circumstances were, I really hate to say this, but every one of these changes, really depending upon what the actual facts were, the needs, the motivations, what options they did or didn't have, just those sorts of circumstances, variables.
Got it. And then second, I wanted to ask about showing properties when they are vacant. As a listing agent, obviously, we want to have buyer's agents provide us with the PEAD signed by themselves and their buyers and adhering to all the guidelines. Do you also recommend, though, too, as a buyer's agent, that you make sure that you get a copy of that listing agreement addendum, or can we ask for that to make sure that the seller has authorized showing of that property before you take your buyer in there?
Oh, I think that's got to be clarified, one way or the other, before that even happens. Now, whether you actually I actually think you want to get a copy of a PEAD, from the seller. I would want to know, if I were a buyer, quite frankly, who else has been there, stagers, cleaners,
Right.
I'm going to make a little joke about this, but when I was reading these forms again, after they came out, I laughed because whenever my wife says, well, go clean something in the house, I go clean it. I think I do a hell of a job. And she comes through and says, not good enough. This is a Dave job, So, one of the realities is we don't know, especially with vacant property, who's been in there or who hasn't been in there, what cleaning, if any, has taken place. We've got all these representations, that certainly it has taken place, but do we really know? And so to the extent that your client is concerned about that, if you're representing a buyer, yeah, Kelly, I'd be saying, all right, who's been in here? Do you have PEADs from these people? Are they current? And then I'm going to tell you something else. There's one sentence in the PEAD. Hang on, I'm just trying to reach for these documents as we are talking about them. That just talks about that the signer of the PEAD is going to tell us, here, it's paragraph 7C. You will inform broker if, after the date this document is signed, there is a change in your health condition or knowledge that potentially puts others at risk or invalidates the representations made in this document. Well, that's a pretty strict requirement. I thought about this and I said, all right, what happens if I sign one of these on Monday and on Wednesday I unfortunately come down with the virus and I'm hospitalized? Am I going to be thinking about, notifying everybody? I think I'm going to have some higher priorities than that. But, to the extent that the message here on the PEAD to me is this: anytime anybody goes into a property, they need to prepare, sign, and date one of these, because your health can change from day to day. There are representations in here that within the last 14 days, I haven't been in contact with somebody who's been infected, but that can change. What would a buyer want to know? Well, I think a buyer would want to know who actually has been in there. Do we have PEADs from them or not? If we don't have PEADs, have we made an effort to try and get them or not? I heard of a situation recently in Santa Cruz County where an agent told me that there were 3 entries into a listed property and no calling, no indication that they were showing up. They just managed to get in. I guess there's some issues about whether the access code was properly set up. But the point is, all right, now we know that there's been some people in there. Do we have PEADs from them? Have we tried to get PEADs from them or not? The PEAD to me falls into the category, the issue of this. It's an issue relating to health and safety. It's the exposure to and potential transmission of the virus. That's one of the things that we're all trying to get our hands around. And I guess we're going to try to get our hands around that for the next at least year until we get a vaccine. And what are we trying to do? We're simply trying to identify that who has been in a particular property, what is their health status, are they following the proper procedures or not? And at least we've got some representations that they are. I wrote down here, how do we know if the cleaning or disinfecting has actually occurred? You know, there's really no way to know. You've got a representation, but if you got a client that's really concerned about it or sensitive about it, you'd probably, as a buyer's agent, want to follow up and find out, all right, exactly who's in there and get me the PEDS. And so that's really how I view that document. But the key to it is, anytime anybody's in there, get a new one, get it dated, get it signed. If people aren't going to sign it, we need to document that. We need to notify people that somebody is refusing to do it. They probably need to be referred to a lawyer, you know, at that point, as to what the consequences of that may or may not be. But those are the primary issues, you know, related to that document. Getting back to yeah.
I'm sorry, just wanted to let you know if we can go for about another 5 minutes, but I also wanted to find out if you in general would be willing to kind of summarize, I know it's difficult, to agents of what you think would be adequate protocol that we should follow to protect ourselves best, whether we're a listing agent or whether we're a buyer's agent, just in general.
Well, I'll tell you what, how I'm going to answer that question. I have an article due for the publication that I write for. We'll leave it at that. And it is due this Friday. And the article is going to be a discussion about, you know, all of these kind of issues and trying to summarize them in some way, you know. So Kelly, I think what I would do is refer people to, you know, that article, you know, so I've been gathering my thoughts about it, you know, rather than trying to summarize it, you know, right now. I've broken it down, and I had started to talk about what I think we should be discussing with sellers. And, you know, one of the things are there going to be any potential delays in providing the necessary transaction documents for any reason? None of this should be earth-shattering. These are things we should be talking about with people, you know, normally. Mm-hmm. Is the seller willing to provide access for the property, and for what purposes? I do think that if a seller is trying to say, well, I'm going to allow access for marketing purposes only, or I'm going to allow a photographer or a videographer, but I'm not going to allow any other access, then we need to have a discussion with them about whether that is a level playing field or not. What are their reasons for that? Why am I saying that? Because think about getting into a lawsuit over this. What is the question that's going to get asked for sure is, well, why did you limit access? And if you were trying to game the system or work the system to your advantage, you're obviously not going to have a lot of sympathy. Nobody's ever going to admit that, but that's going to be what people are going to be looking for. The other thing is, we ought to be at least having a discussion with a seller about, do they want to initial liquidated damages? That may be a function of how steep a decline in the market we think the property may experience or not, but that's an issue. And now, in terms of buyers generally need to understand, what ability am I going to have to evaluate the condition of this property, and am I willing to accept the risks associated with that? From a broker standpoint, Kelly, if a seller isn't going to provide access, or access is not possible because it's occupied, then how far of a virtual transaction are we going to go? Do we need to have some documents created? And the answer is yes, which identify the limitations on our ability to conduct or complete our activities, such as completing a visual inspection of the accessible areas of the property, final walkthrough. One point I'd like to make is waiving the visual inspection of the reasonably accessible areas of the property is, in my opinion, not an option. Now, can we qualify or excuse the level of performance that we are going to be able to take? Yes, but I mean, even if you can't get into the inside, you can still walk around the outside. You can still look in windows. You may or may not have knowledge and information based upon prior visits before these things occurred, prior photographs, prior transactional files. You know, any of these things, we still have an obligation to disclose what we know. and we have an obligation to complete the inspections to the ability that we can, and to notify our buyers of the limitations and restrictions and advise them of the risks associated with that. I'd like to conclude with a comment that I got from a broker client of mine. This was about 3 weeks ago. His observation about this, and he's been in the business longer than all of us, or at least longer than me. His observation was, we have been dealing with unforeseen issues throughout our careers. They come up all the time. They may not be of the magnitude of COVID, but how have we dealt with them in the past? By negotiating, by talking, by trying to work things out. And we ought to continue to do so. The only other thing I'm going to tell you, Kelly, going on to the buyer side here is, we need to be focusing a little bit more on the concerns that buyers may have on, well, my funding. Now, how many of you remember CAR used to have an option in their contract that the loan contingency could be removed upon funding rather than on a specified date?
Yeah.
Well, I mean, do we want to possibly go back to that? Now, you've heard me say this before. I'm going to say it in my article. I'll say it again right now. Every one of these choices, decisions, outcomes, whatever you want to call it, depend on what? Market conditions, buyer and seller motivations, needs and wants, the scope of these SIP orders. Every single one of these things has these variables. And if a buyer is concerned about financing and the market is going to allow him or her to write an offer with, I'm removing my loan contingency upon funding, maybe we're going to need to go back to that, right? Maybe we need to consider that. If they've got gift money that's coming, if it's gift money, find out about it and put a contingency in there if somebody gets cold feet that's given the gift. If they're worried about their stock, write a contingency. So, I mean, all of these things, we need to realistically assess what the needs and wants, the motivations, the market conditions are for everybody at the time we're writing, and address them. And unfortunately, if the seller says, I don't care, this is what I'm going to require, fine. They're going to dictate whether or not that's going to, those contingencies are going to be acceptable. But I mean, I think that's really where we are in terms of confronting this, rather than putting a COVID addendum on a contract right away. Now, you need to get the addendum to the listing, that I believe, and I also believe you got to get PEDS. But I'm talking about, let's just write a realistic offer based upon the needs and wants and market conditions, give ourselves enough time. And I want to leave with this one thought. Every time that we have removed a financing contingency in the last, since it's been on a date certain, what are the consequences of doing so? The consequences are that in between that date and close of escrow, the lender says, no, I'm not giving you the money for some reason. And it may or may not be within your control or not, but that's a risk that we have always taken as buyers. And what do we recommend to our buyers? Go talk to your lender directly, go get confirmation that you've got your money and there aren't going to be any hangups, there aren't going to be any requalifications or hiccups. Now, can you get that from the lender? Maybe, maybe not, but that is the risk, that exists. And as I said, 14F allocates that risk, at least in the pre-printed language, to the buyer once they remove their contingency. And in fact, the COVID addendum, the newest one, this is the one that's dated April 16th. It says under paragraph 4A, the time to remove the following contingencies, provided they have not already been waived or removed. So they're already building into this that notion. The other last thing I'll leave you with is 4A, B, and 5. You got to read these very, very closely depending upon who you're representing and what impact this does or doesn't have. Remember, You can present this COVID. It doesn't have to be signed. It requires mutual, agreement. And the NUCC is the notice. Again, it doesn't necessarily have to be signed. All right, with that, questions? I'm more than willing to hang around and hear what the real issues are so I can include them in my article.
Dave, Tiger here.
Yeah.
Appreciate your comments. Always great to hear what you have to say. Two things. One is, most recently, you talked about removing the loan contingency. That, in my opinion, has been the biggest unattended to issue in almost every deal, because the lenders often say that if we have a date certain to remove finance contingencies, the lender doesn't care if you and I as realtors have put our clients at risk. And I think almost every time there's a loan, there's a delay. So I'm glad to hear you address that issue, and I think it does need to go away to make it easier for us to transact, because it is a source of contention between the buyer's agent and the seller's agent, and also the clients themselves. So thank you for that.
Could I just jump in and give a quick response? Remember, we've had issues like this before, maybe not to the same degree. I'm not suggesting that it is, but I also remember drafting and trying to negotiate on behalf of both buyers and sellers language at contingency removal, that addressed some unforeseen circumstance, in the future. Remember, we got hung up on language like through whose fault, through no fault of buyer, that sort of thing. We've been through this in other markets. My point is simply that we always have to take it in the circumstances of the particular motivations and leverage, that the buyer and seller each have. That's the dilemma. I have not heard of any industry-wide, let's go back to upon funding. But I mean, why can't you include that if, the market will let you, which would at least eliminate or alleviate some of these issues. Yeah. Or if you've got a fixed date, then at that fixed date, before you have to remove, you reach out and you say, look, how receptive are you to the following? Here are our concerns. That's what I think we should probably be trying to do.
Yep, I totally agree. The second part of my question is pertaining to showing of occupied properties by allowing buyers to visit the backyard. Is that in compliance with the current rules? In other words, buyer is home, waving through the windows, and people are going in the backyards.
I'm sorry, the seller is home.
The seller is home.
Right.
I'm asking because I have an occupied property that they would like to have buyers come by and take a look at the backyard.
And the seller has agreed to access.
Yes.
Okay.
So
well, the short answer is, I don't know. I am reaching as I'm trying to, I'm reaching for the SIP order, for Santa Clara County.
Yeah. We've been using the word access. So access is okay. Well, we're not accessing the structure, we're accessing the property by merely going around the house, going to the back.
Okay, but hang on. And your first name is Tiger?
Tiger, right.
Okay. The language in the version of the ordinance that I'm looking at says, provided that appointments and other residential viewings must occur virtually, or if a virtual viewing is not feasible by appointment with no more than blah, 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 blah. Okay? Yeah. Now, the problem we've all got is the words that are in these ordinances were drafted by health officials and county council without any understanding of how we do business, and how we use terminology. So viewing some people have tried to, interpret that as, well, that is a showing for purposes of writing an offer, a viewing, as opposed to any other viewing. But to now answer your particular question, I'm sorry, I don't know whether they're going to interpret viewing as meaning interior or the entire property. You see my dilemma?
Yeah.
That's the issue. And look, none of you should be relying on, Dave Hamerslaugh's interpretation of an order absent, a much more detailed discussion of the facts, circumstances, and what's going on, because we're all looking to get some sort of statement or pronouncement of what we can or cannot do. And I'm afraid that it really has to come from the government, rather than yours truly or others. We can give you what we think might be a reasonable interpretation or not under the particular circumstances. But, you've actually just identified an issue for me, which I got to give some more thought to, as a matter of fact, as well. Good question.
Anybody else have any experience with that?
I'm sorry, Tiger, I would love to have a debate with Dave here, because he's got a lot of information, but I know that we have a limited time, and I have a lot of other people that are sending me questions, and I would love to have Dave just go endlessly. But I do want to be sensitive to his schedule as well as everybody else attending the meeting. So sorry to cut you off, Tiger. I don't mean to be rude.
Well,
David,
Kelly, can I just say one thing?
Mm-hmm.
Anybody, I gave you my cell phone.
Mm-hmm.
It's 408-888-0302. My email is Dave, D-A-V-E, @rhrc.net. Because look, guys, this is how I get better. Okay.
Mm-hmm.
I mean, you guys bring me real world issues, that's how we all improve. So please, I'm willing to stay on and talk some more, but if other people don't want to hang on, they got to do something, you want to drop me a note or something, please do. And I'll try to get back to you, because it's going to make me better at what I do.
I really appreciate that, Dave. I do know that there's some people that have some properties that they had planned on promoting. If you're not looking to race out Dave, I don't know if there's anybody else. Jody, I don't know if we can do that, if there's at least a platform where they can keep chatting, or I would recommend that you contact Dave. He's been willing to give his cell phone number and email address. So I would encourage you to reach out to Dave and read his newsletters. Well,
like I said, some of these things are going to be in my, next article. And, just recognize an article can't address everybody's, situation or every circumstance. There has to be some generality to it, but I'm going to be going over these basic kinds of issues, and a lot of it is simply trying to just raise or identify issues, to be thinking about. All right.
Perfect. And Dave, what is your email address again, Dave?
Dave, D-A-V-E, @rhrc.net.
Okay, I'm putting it in the chat box right now for those of you who didn't have pen and paper. Also, we wanted to remind you that clear cooperation goes into effect the 1st of May. So please keep that in mind. And I'm just looking to see if anybody else had a property they needed to pitch. I think we got everybody covered.
Kelly, I have one more.
Yes. Okay.
This is Rod again. We have a 55+ condo in Los Gatos Villages, 600K. I'm just putting the details here. 2-bedroom, 2-bath, vacant, staged, and all the inspections are done. Matterport, everything's complete there. I'll finish putting the information in the chat box for the address. Thank you.
Okay, perfect.
Kelly?
Yes.
I'm sorry, Mark again. Apologize. I just want to remind people they can save the chat, because people, you may want to see these phone numbers and such. If you look under the chat button, there's 3 little dots, and all you have to do is push those dots and say save chat. This way you can look back, get that information that was shown or discussed.
Perfect. And I believe we're recording it too, right, Jody?
We are. And then Dave, if you can repeat your cell phone one more time, I just want to make sure. And as you're saying it, I'm going to type it into the chat box for everybody.
Sure, thanks. 408-888-0302. 0302. That's my cell phone.
Thank you. And yes, we are recording this and we'll get it onto the Facebook page.
Okay, perfect. Now that pretty much concludes the tour meeting. But again, since Dave is so gracious to spend more time, then please feel free. I'm going to let you guys pretty much moderate so that you're not always throwing questions at him at one time. I have to leave, unfortunately, to another meeting. Thank you, Dave, so much. I appreciate you.
Thanks, Kelly, for having me.
Absolutely. And we will have you back again soon. A lot of changes to stay on top of. Everybody have a great day. You too,
Thank
Lucy.
you.
Thanks.
Kelly,
Bye-bye.
bye-bye.
If he wants to stay on with
Kelly.
Dave, you're more than welcome. I don't know if he jumped off.
Oh, he's right
He's
there.
still there.
Shift it up. Can I ask Dave a question? This is Jim Myrick. Dave, how you doing?
Hi, Jim. How are you?
Good to see you. Hey, just
Likewise.
real quick, you put fear in me right off the bat on your liquidated damages interpretation on going beyond the liquidated, that the liabilities beyond the liquidated damages. Is there any case law or anything like that that has shown that somebody else is been liable for above and beyond liquidated damages?
The answer is there's appellate law that upholds the remedy of specific performance on the part of a seller. Jim, the issue is, does the language in the liquidated damage clause indicate that liquidated damages is the sole and exclusive remedy, for the seller in the event of a breach by the buyer? If you look at the CAR language, it doesn't say that. And it also, if you look at some of the CAR literature, it also suggests that specific performance is a viable remedy. The Civil Code also says that specific performance is a viable remedy, even where you have liquidated damages, provided that you don't have some agreement that limits it otherwise. Now, Jim, I'm in my 40th year of doing this. My partner, Ron, has been doing this 52 years. And our colleague, Vicki Nadorf, has been doing this 45, I think. Between the three of us collectively, we are not aware of a seller-specific performance action that has gone to judgment, in that time, primarily because of the fact that unless you reach a stipulation otherwise, the property needs to remain off the market, because in order to accomplish specific performance, you have to what? You have to be able to sell the property to the buyer, even though the court's not going to enforce the purchase by the buyer. But you still got to be able to have that there. So what I've tried to negotiate is our stipulations, that will sell the property and turn what is essentially a specific performance action into a damage action that we have liquidated the amount of damages. Now, would a buyer agree to that? Not necessarily. But I can tell you this, it has been in 10 letters I've written, on behalf of sellers here that have been using CAR contracts, at least, as a viable potential remedy.
Yeah, I guess my concern from a boots on the ground kind of setup is that agents are thinking that they can go through the specific performance as opposed to getting their clients to neutral positions by using the liquidated damages. I just wanted to be concerned over, I think sometimes people hear this and they start, all of a sudden they lead with that to push the buyer into, what they're subsequently trying to do is to get the buyer to close. I just, when I heard that, I just wanted to make sure, I just wanted to see how viable that is, because a lot of us have advised our clients going like, well, obviously you always lead with talk to your attorney, but the intention of this was to limit the liability to your buyer through the liquidated damages clause. But you're saying that it can go above and beyond the liquidated damages clause. It's viable to do that.
Yes, what I am saying is I'm trying to address the belief on the part of a lot of licensees that by initially liquidated damages, that is in fact, the sole and exclusive remedy. And under the car contract, I don't believe that it is. That's all I'm trying to alert people to, because I can't tell you how many communications I've read on behalf of buyers' agents in the last 40 days, which have said, due to unforeseen circumstances or COVID-19, my clients are not in a position to perform, and we can cancel. And well, the first thing is they get their deposit back. The second thing is they don't realize that that may not be the sole and exclusive remedy. So to address your statement, I hate to say this, but at some point, people need to realize, licensees need to realize when they need to consult with their manager first, and or, a qualified California real estate attorney before they write or submit or present any of these emails or requests or forms, right? That's the bottom line here.
Okay, so I mean, just so everybody on the call, I think probably the biggest one that I would say is that consult with your attorney on the interpretation of this and how you want to handle that. That's really what you're saying, and that going beyond the liquidated damages is a possibility, but it doesn't sound like the risk management needs to be between you, your broker, and counsel.
Yeah, and Jim, you've known me for years. I don't like telling any of you, well, you got to go see a lawyer to do anything. Okay, I've never been that type of lawyer, and I don't want to be that type. But there are just certain things that are happening, and if they happen repeatedly, I think it's my responsibility to just point that out. And what I saw and still am seeing are what I just said. I get an automatic get out of jail free card for whatever reason, and my liability is limited to 3%, but I don't even have that exposure because they think that they've got an excuse for non-performance, or justification. That's all I'm trying to alert everybody to.
Got it.
Okay.
Good seeing you again, but thank you very much. Appreciate it.
Yeah, likewise. Anybody else?
Are there any other questions? I haven't seen anything come through the chat in a little while, so.
Hey, Jody, it's Mark, the shy one.
Yeah. Mm-hmm.
Hey, Dave.
Hi, Mark.
Hey, man, I tell you, man, I love you, baby. Let's get married. No, I don't want to marry you. That'd be too
That's
sad.
that jail behind you. What are you
Not
talking
today,
about?
Mark. Not today.
No, that's not jail. I'll show you my jail one in a bit.
Mark, be careful. This is being recorded.
Okay. Thanks, Rod. You mentioned about your newsletter. How do we get your newsletter?
Well, I write an article once a month for another publication. SCORE was nice enough to, I guess, sponsor this or, ask me to be involved along with Kelly and others. But, Silvar's got a monthly newsletter and I write an article for it once a month. And then that article gets posted on my firm website, a day or two later. So if you go onto the firm website, and Mark, you know me, I'm technologically bankrupt. I don't know where it is on the damn site. I'm just told that you can go on there. And I mean, I've been writing articles for, I want to say at least 10 years, 12 years. I mean, for that publication. So there's a lot of information on there. And I'm going to tell something else. There's a lot of other competent and qualified lawyers out there who also write great articles, and I'm not talking just about Vicky. There's all sorts of other people out there that have knowledge and insight on this stuff. So if you search anybody's website, I think you can probably see if they publish and to what degree. But thanks for asking.
No, and also I may want to. Oh, there's my place. This is where I'm at right now. My friend's back there. Wave at them. Listen, one last thing. I do encourage you to join us on that Monday mastermind meeting, because it'd be good to have you here and hear a little more about this clear cooperation. One of my biggest things that I don't like personally, but we're gonna have a big panel there, and I'm sure there's some people that want to talk about the constitutional rights and all that kind of stuff. But if you can, I'll send you an invite. to join
No,
us.
you sent me one last time. You know, like everybody else, I'm just trying to earn a living. You
No,
know,
it's
and
gonna be good for you to sit in.
Uh,
You mentioned you want to hear what's going on out there.
oh, I know. I just, I have got, you know, deadlines that I've been working on, and, you know, believe it or not, in spite of the fact that the court system is shut down, you know, there are still problems, and there's discovery disputes and things that are still going on. So I'm knock wood, I guess, is what I'm saying
Okay.
for me.
Well, you're always invited. Thanks, Dave.
Thank you again.
Doug Goss had a question for you.
Hey, Dave, thanks for coming on with us today. We appreciate it. I just wanted to,
Hi, Doug.
would you mind just touching on, you know, we see a lot of people bending the rules on the SIP, and what the risk is potentially with their doing something in violation of the SIP, or having their clients do something in violation of the SIP, and how that may affect their coverage under their E&O insurance.
Okay. First of all, the SIPs indicate that the violation is a misdemeanor. It's punishable by a fine and/or imprisonment. There is a potential, depending upon the facts and circumstances, Doug, that if a seller is either fraudulently induced, you know, to sign a listing in violation of an SIP order, or to perform an act which is in violation of that SIP order, that a broker, you know, could have some liability for that. Broker might also suffer the consequence of their listing being canceled or voided. I mentioned earlier, you know, if a buyer knowingly and willingly participates in an illegal transaction, you know, it may be very hard for them to say, well, now I want to, you know, get out of the transaction because it was illegal, you know, because it violated an SIP order. I have just heard anecdotally that the police, sheriffs are actually stopping people in various counties because it seems that people are traveling from one county into another really just for pleasure. And, you know, whether they're just warning them to begin with, whether they're fining them, I've heard both. But it's all anecdotal. You know what I'm saying? I haven't personally experienced it. There is a concept called aiding and abetting, which, you know, a broker might get sued for. There could be potential ethical claims because some people think it's unethical to do that. And that, you know, kind of runs, you know, the gambit of what I can think of at this point in terms of what are the consequences. Did you have something, you know, more specific or beyond that?
No, I was just curious, you know, if something were to happen, say to a, you know, say someone shows an occupied property, right, against the SIP, you know, in violation of the SIP, and somebody gets sick, and, you know, now everyone's suing everybody, and your E&O would not cover you under that since you.
I'm sorry.
Yeah.
You did mention E&O. So first of all, let's start with the fact that all of the car forms do what with respect to this? They all say that the brokers are not going to violate any SIP order and recommend that nobody do so, right? And this is all throughout these forms. Well, are those forms going to be a bulletproof vest? It just depends on the facts and circumstances. I mean, it's a piece of paper that is designed to provide a level of protection, but if a broker knowingly participates and violates in an SIP order and causes other people to, there may be consequences. As far as a personal injury claim, you know, because somebody got exposed to the virus, I think the biggest issue is going to be, how do you prove that they contracted the virus as a result of that particular visit, you know, or circumstance? So there's a causation element that may be involved. And as far as E&O coverage is concerned, E&O policies typically do not cover personal injury claims. They certainly exclude intentional acts. So you might end up in a coverage battle with your carrier over whether this was an intentional violation or an inadvertent violation. And, you know, you'd be in a battle over that. But that's what I can think of on that front.
Okay, fair enough. Thanks.
You're welcome.
I don't think I've seen any more questions come in. Is there anything else for Dave before we let him go? Okay.
All right. With that, Jody, thanks very much. Thanks, everybody. Have a good day.
Thanks, Dave.